All right, thank you. There's someone who's identified as Moto G Play 2021. Could you please tell us your first and last name, please?
LaShawn Courtright. How you doing, Judge Washington?
All right, Miss Courtright.
I see you're having a challenging day.
Yes, one of those already. Thank you.
We've got to get our stuff together because without one another, we're nothing.
All right, thank you. Thank you, ma'am. State of Michigan versus Riley Jager. Unfortunately, we've got 43 on out for the next 2 weeks, so you'll be looking at 3 weeks out. And we can do that. Are you available
Yes, Your Honor.
September the 2nd?
It'd be August 26th.
August 26th. Are you available on that date?
Yes, Your Honor.
Right.
I have a question.
Yes, Mr. Gray.
I'm supposed to be getting my medical card. I've been smoking weed since I've been like 13 years old. So I don't know how that works with you guys. And it's like, I've been smoking weed since I've been 13. The only time I usually stop is when I get locked up. And I don't know if I'm not, like, is that part of my bond to not smoke weed if I get in a card?
It is a part of your bond until I approve otherwise. And if if this involves, and it doesn't appear that it does, at least not this particular charge, but there is another charge. I don't know whether that involves a violation of MMA Act. If there's no violation of the MMA Act, then what I look at is whether or not there's a medical necessity for you to have to smoke marijuana, sir.
Okay.
All right, so all of these matters are adjourned to August 26th, 2021, and that's at 9 a.m.
All right, Mr. Gray, you need to come in and see me, okay?
Mr. Gray, I heard what you said about smoking, but it sounds like you don't have a card at this point, and you're on bond, and you should not be smoking. So your levels need to start going.
You want me to do it today?
I'm sorry?
No.
Are you talking to me, Mr. Gray?
I'm
All right, Mr. Goldstein, I think you're
breaking up.
your
My phone.
is breaking up. So can you?
Yeah, I was hearing you, but my phone, when I was speaking, it probably just cut you off. I'm sorry.
That's okay. All right, I need for your levels to start going down.
Yeah, my phone's breaking up.
All right, Mr. Goldstein, please speak to your client about that. Okay.
I will, Your Honor. I will also explain to him what
Okay.
he said, that he only stops smoking when he's in jail. If he doesn't stop smoking, he'll be in jail.
Thank
He
you.
has to understand that. So I will explain that to him.
Thank you so much.
Thank you.
All right, we'll see you both back here on August the 26th at 9 a.m. Bond is continued.
Thank you, Your Honor.
Thank you. That's the last one for Mr. Wilson.
He's got 10 minutes.
State of Michigan versus Alyssa Mullins, case number 21 S00221.
Laura Bloomberg on behalf of the people.
Good morning, Mr. Torres. How are you?
I was good. Good morning, Your Honor. William Mays on behalf of Ms. Mullins, who's out in my parking lot right now. I've got multiple Zooms going on as we speak. I had asked if there was an offer on this case in the chat to see if...
Yes, Your Honor, I have been dealing with other matters, so I did not have an opportunity to answer that chat. This is a high BAC case. I will offer an added count of OWI first, and in exchange, we'll dismiss count one if Ms. Mullins would like to resolve this today.
Okay. All right. If we could just pass on this matter, Your Honor, I'd appreciate it. I'll talk to her about that, and I'll be done in the other court here in just about 15 minutes.
Thank you. I will pass this matter.
Thank you, Judge.
State of Michigan versus LaShawn Courtright, case number 20S00541.
Laura Vollenberg on behalf of the people.
Edward Drukas for the defendant.
I want to say to you today, Your Honor, to both you and Mr. Drukas, I admire your admonition for the law.
Thank you, Ms. Courtright. Let me talk to the judge real quick.
Sure.
Your Honor, today is the time and date set for a pretrial. We have received an offer in this case. I have been reviewing that with Ms. Courtright. There's a couple other things Ms. Courtright wants to discuss with me. I'd be asking if this court would set this for a final pretrial. Right now, she has the idea that she'd like to set this for a jury trial.
I don't. It's just that Erica Julian pushed me to this
that's
point
okay. That's okay, Ms.
without
Courtright.
conferring with me. Tell the truth. Tell the truth.
We'll continue to talk, Ms. Courtright. Don't worry. You'll
Yes,
be heard.
indeed. All right.
So with regard to
return my
that,
calls when I call you then, Mr. Drukas.
okay, thank you so much.
Don't ignore my call.
No problem,
I
Ms.
care
Courtright.
about you. I know you drive a white BMW compact SUV, family style. Am I right or wrong?
Thank you, Ms. Courtright.
Because I was hollering at you across the street the other day, just Thursday or two, whatever. And I really respect the court and what it stands for. I just want a fair chance to enhance my life. Like
Thank you, Ms.
never
Courtright.
before. I love y'all. Have a great day.
Thank you, Ms. Courtright.
Always. Thank
So with regard to that,
Thank you, Judge Washington.
You're right. You're
You need to answer my calls, Mr. Drukas.
Ms. Courtright, ma'am. We heard you. He heard you.
I love y'all. Thank you.
Thank you. Mr. Drukas, the earliest date we have for final settlement conference at this point is the November 18th date.
Okay. If we could
Thank
set
you,
it,
Judge Washington.
I guess between
Thank
now
you,
and then,
Drukas.
if we could set it for that date, Your Honor.
All right, November 18th, 19
Thank you, Your Honor.
at 11 a.m.
Always.
And then December 3rd, 2021 for trial. So jury selection.
If it goes that far.
Yes, true, Ms. Courtright.
Thank you, Your Honor.
Mr. Drukas can reach back out to us at any point in time if you reach a resolution, and we'll put it on.
Thank you, Your Honor. I appreciate you. But I do think that if Patricia Risers, one of the prosecutors on this case, she's
Thank you, Ms.
biased.
Courtright. Let me speak for you, okay?
Okay.
Thank you.
yeah.
Well, I'll call you in a second, okay?
Thank you, Mr. Drukas. Have a great
Thank you, Ms.
day.
Courtright.
All right, thank you. We're all set. Bye-bye, everyone.
Thank you. Have a great day.
Laura Vollenberg on behalf of the people.
And good morning, may it please this honorable court. Deanne Webster Cox appear on behalf of Mr. Jones. How are you, Your Honor?
I'm fine. How are you, Ms. Webster Cox?
I'm good, and my client is present via Zoom. Mr. Jones, state your name, please.
Keontae Jones.
Well, Mr. Keontae Jones.
So, Your Honor, this is the date and time set for the sentencing. It did come to my attention that my client was a no-show for the assessment. So there are several things. Number one, my client was in an interview yesterday, and he should be gainfully employed. And that's number one. Number two, I know there was a question about whether or not there was a fire, and I did send over documents that I received from my client, and he wanted me to share with the court regarding the fire and whether or not it took place. So there was a report by Elite or Image Trend Elite. It's an NFIRS-1 basic report that details the fire that took place on the date. That was one of the things that my client was saying, that he did not have a place to stay and did not have any money because of this house fire. So with respect to the 1 and 2, I'm requesting a one month adjournment The court was so gracious enough to reduce the price of the assessment, but now that my client is employed and working, he can pay for this assessment and we shouldn't have this issue. That's my prayer for the court.
Mr. Heaton, are you in receipt of a report regarding the fire in this particular matter?
I didn't send it to him. I just sent it to Heather Ball. I can send it over to Mr. Heaton now.
Okay, 1 second.
Okay. I just received it this morning.
Thank you. I am in receipt of the NFIRS 1 basic report. It does not, indicate, at least I can't tell from this brief review of it since I'm just getting at the actual extent of the damage.
It does on G1, Your Honor. I mean, G2, under estimated dollar losses and values. Oh, Mr. Heaton, let me send this to you right now.
We've sent it to him already.
Oh, okay. Thank you.
So the pre-incident value was 175, and now it had a property loss of 75,000.
Right, that's what I see in contents.
I don't see that it shows a total loss, but it clearly shows that there was some type of fire. Where is the address on this?
The address is on the first page. I see 19. It's under B, section B, location type.
Okay, on Ohio Street. Okay. All
And
right.
that address is 189.
Yes, I see that.
Okay.
Thank you. So here's a couple of problems that we have. We need a breakout room on this, please.
Okay, thank you.
Received some very disturbing news. You have new charges, sir?
Well, they
That's a yes or no question. Do you have new charges?
Yes, ma'am. Yes, ma'am.
That's a problem. That's a violation of your bond. You understand that?
Yes, ma'am.
You have not gone to have your probation report done, your assessment done, as you were told to do. This is my second time telling you to go. And you're claiming that you don't have monies when in fact it appears that you're using marijuana and cocaine.
I've had negative drops. I have.
By negative, you mean positive drops? Because you're positive for THC on July 22nd and cocaine. That was just a little over a week ago.
Yes. By negative, I do mean positive. I've been going down firms.
I'm going to be very clear with you, Mr. Jones. I'm going to re-refer you for this report one more time. You don't go to this report, you will be going to jail. I can get the report done that way. Do you understand me?
Yes, ma'am.
All right.
Thank you, Your Honor. Thank you.
Wait, we're not done yet. So we're going to have you back here for sentencing on it's the third. Let me just look at it. No, that's too far. All right. So September 2nd. That means you need
You said
to
September?
Yes.
September 2nd?
Correct. So that means you need to get on this right away and call over today to get this assessment done. You got a shorter time period. You understand that, sir?
Yes, ma'am. And I do have my medical information
I don't even know
for
what
the
that means.
marijuana.
Well,
Medical card.
I have not approved for you to be using any medical marijuana.
Yes, ma'am.
So until I approve that, you can't use it. And it has to show necessity. I have to review a letter from the doctor that says that. And I need to determine whether or not you're in violation of the MMA Act. So those are the things I'm going to be looking at. So as of now, you cannot use any THC and you certainly can't be using cocaine.
Yes, ma'am.
In addition to that, I'm referring, you have a $60 re-referral fee. Cocaine costs, so does marijuana. Pay your actual referral fee. Get this done, or I will send you to jail. Okay?
Yes, ma'am. Yes, ma'am.
September 2nd, 2021 at Roper 21C 1146. You may enter your appearance now.
Sorry, Your Honor. Jordan A. Schoen for plaintiff's attorney for LAF QP number 84339.
Thank you. Mr. Roper, how are you today?
I'm not good. I'm sitting here looking at y'all.
Oh,
My
wow.
health is okay.
Your health is okay?
Yeah.
We're causing you that much distress?
Yeah.
Oh.
This is the situation. I know. Do y'all want to hear what's going on?
It's your motion to set aside the default today, sir.
My motion.
I'm sorry?
I'm in West Willow and they have that plane thing going on today. Well,
Yes,
they
they do.
practicing.
Yes, they are practicing.
Blue
Angels.
Yes, the Blue Angels. I co-signed a loan for my son, my stepson, and he apparently skipped out on me and the loan. So now I'm stuck with it. But my understanding was that if they came and got the car and sold the car, I would be responsible for what was left after they sold it. That was my understanding. That's first. Secondly, I wasn't even warned about the first court hearing. I was on vacation on the first court hearing.
Your Honor, if I may.
All right. Just 1 second.
Okay.
So, sir, you're here, you filed what's called a motion to set aside a default. And so there are, with that motion, you have to prove two things. One, that there's good cause, and two, you have a meritorious defense. So those are the two things that have to be shown in this particular motion. Did you file this yourself or someone else filed this for you, sir?
I filed it myself.
All right, now you may go on, Ms. Ashion.
Yes, Your Honor. We did file a response, and part of what Mr. Roper just explained is let me back up. He was served with a summons and complaint by personal service on May 3rd. He failed to respond or file an answer to that complaint, which sounds like all of the defenses he is now claiming should have been in a answer, and he failed to do so. So after 21 days of service, we filed a default judgment. His claim that he missed the first court date is there was no first court date because there was no answer filed to initiate a court date. He has not shown good cause as out of town to visit his grandkids, and missing a court date is just, as I explained, there was no court date, and also he has already admitted to co-signing on the loan, so therefore there's no meritorious defense or good cause as to why the default judgment should be set aside.
Now, in response to what she's saying, you guys said that y'all came out here and had someone 6 foot tall, 200 pounds sign something one, I'm in a wheelchair and I'm barely 4.5 feet tall. Two, I'm only about 140 pounds. So therefore, whoever you had sign whatever they signed wasn't me. So therefore, whatever I'm talking about, I missed because you didn't give me any notice. Would you please read your paperwork? I've been in a wheelchair for 20 years, paralyzed from the waist down. I'm in an electric wheelchair, 140 pounds, and I'm probably 4.5 feet tall. I'm in 140 pounds, not 6 feet tall, 200 pounds.
Your Honor, may I respond?
Yes, you may.
I assume the paperwork he is referring to is the proof of service. We don't have anything indicating that he's in a wheelchair. Also on the proof of service,
Correct.
signed by,
Mr. Roper, please let her finish her statement.
signed by Jim Marker, the process service says he is in his 40s, 5'10", 200 pounds. So this doesn't say he's 6 foot. And I mean, there was no mention with or without a wheelchair. He also, I'm not sure if he was referring to him signing any paperwork as if, you know, like a personal affidavit, but there's no signature by him either way.
So that's my point. I did not get any notice. I don't know what I need to send in showing you I'm in a wheelchair or what I need to show you, but my point is you didn't give me any notice. I don't know who signed what, but I wasn't here to sign anything and was not notified about the last court date.
There was no signature required by you.
All right, stop arguing. That's enough.
Court date. I'm sorry, it's not, well, whatever it was a notice for me to appear or whatever. I'm not good with whatever's going on. This is the first time this ever happened to me. It's not like I'm in the courtroom every day like the young lady is. So I don't know all the lingo or what's going on, but I know I wasn't there the last time I was supposed to be, or I didn't do something when I was supposed to.
All right.
So I tried to take care of it this time, and that's why I'm here.
All right. Thank you, Counselor. Thank you, Mr. Roper. Mr. Roper, just so that you are clear, Counsel is right. You don't have to sign for a document in order to be personally served. And secondly, once service is made, it is incumbent upon the person who was served to actually file an answer. If an answer is not filed, then a default can enter. Now, Ms. Ashion, Mr. Roper is absolutely correct. This document here says that they served someone who is a Black male in their 40s, 5'10", 200 pounds. And that is what I get from what's written on that. It at least creates a question of fact as to whether or not he was actually served. So that is a question that this court has. You have the option, ma'am, to bring in your Mr. Marker to explain what that means at the bottom of that document if you so choose to do that. But at this point in time, it appears to me that there's certainly a question as to whether they served the proper person. If he has not been served, then he would not have an opportunity to file an actual answer. As to the meritorious defense, I believe that although he may have admitted that he signed a loan, there is still a question of fact as to how much would have been owed after that car was actually sold. So that does present a meritorious defense as to at least the amount of money that is in question in this case. So that's where I am on this today.
May I?
Yes.
Okay.
Ma'am.
So would we be able to reserve him? My question would be that the summons has expired on 8/3, so maybe get an extension of the summons date to properly serve Mr. Curtis. And I would also like to confirm, I guess, his address and just make sure we are getting the correct person. Or I could also reach out to the process server and try to get a better affidavit description, although this is the one that he has. I'm not sure if he'll recall on that date. So I think the best course of action would be to reserve Mr. Curtis, if that's what the court would desire.
His name is Mr. Roper.
I'm sorry. I'm sorry, I'm looking at a different file on my computer and I'm looking at his
Yeah.
correct file on my, I'm sorry.
All right, thank you. Well, Mr. Roper, I'm gonna grant your motion to set aside the default in this case. I just, it's very troubling what we have here versus who he is. So first of all, let me swear you in, sir. Mr. Roper, raise your right hand. Do you swear firm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Sir, I'm looking at your little teeny arms over there. It looks like you
Correct.
probably do weigh about 140 pounds.
Correct.
So is it your testimony here today that you only weigh 140 pounds?
Yes, ma'am.
And how long have you been in a wheelchair, sir?
Approximately 20 years.
All right. I'm gonna set aside.
I can send in doctor's note if I need to.
I understand, sir. I believe that you're in a wheelchair and that your weight is about 140 pounds. The affidavit in this case, well, the notation on this proof of service shows a black male 40s, 5'10", 200
Your
pounds.
Honor, I'll be 50 on the 21st of this month.
You're still in your 40s though.
Oh, yeah, well, yeah.
I don't understand what the other part says. Don't have hair. I'm not sure what that even means either, but yep, you got plenty of hair. So, you know, I'm willing to set aside the default. On the other hand, Ms. Ashion, I don't think you need to reserve him. He is present. He's aware of it now. What I need you to do is provide him with a copy of the complaint in this particular case. Okay?
I can do that. Would by first class mail, Your Honor, or how would you like me to?
How would you like to receive this complaint, Mr. Roper?
What's going on now, Your Honor? May I ask? I don't even know.
Well, you're being sued well, you know what's going on. You're being
Yeah,
sued.
well, I know I'm being sued, but what do you mean receive a complaint? I already know that she's suing me. I need her
Did you actually get the complaint is what I'm asking about. Do you see
well,
that?
she can send it to me in the mail.
Okay, thank you.
She got my address. She gave the right address.
So then you can send that to him in the mail. And then we will deal with the actual case. I'll give you a pretrial date.
So I gotta go back. I gotta come back to court.
That's what you came to court to do, to set it aside so you could deal with it on its merits, right?
Right.
All right, so yes, you gotta come back to court.
So how can they sue me for the entire loan when they took the car and sold the car and they told me that they told me whatever they sold the car for, I would be remainder for what's left between that and the loan.
It sounds, well, I don't know. I haven't, it looks like the loan balance and the repossession costs. Was this vehicle sold?
It was, Your Honor. The difference in the loan amount and let me see here.
Yeah, your loan balance, sir, initially was $8,033. So they're suing you for the balance, the $5,000.
Okay, now I'm on Social Security disability and I'm getting $1,000 a month. So I'll wait until we go to court.
You might want to call them up to talk to them about this matter to see if there's a way that you can reach a resolution with them or not. That's up to you. It's Ashion's office.
Well, that's what my problem is. They could have did that before we even came to court.
Okay.
They never even contacted me about this situation. They just automatically want to go to court.
September 23rd, 2021 at 2:30 p.m. for pretrial.
Your Honor, if I may just ask, so it's his verbal argument, his response, or are we having a pretrial in the event he files a written response?
I'm sorry. Yes, oh, so you need to file a written response to the actual answer. If you don't, then you can be defaulted again. So you need to respond to their actual complaint. You need to file an answer.
Before they sign, before I come back to court?
Correct. You have, once they've served you, she's serving you by mail. It'll say on that date, the date that they say that they served you. You have 21 days from that date in order, was it 28 based on 28 days from that date in order to actually respond. Okay.
Yes, ma'am.
All right. Thank you.
Thank you.
You're welcome. Thank you.